In the summer of 2011, the Supreme Court ruled on the landmark sexual discrimination class action lawsuit Dukes versus Walmart. The court reversed the Ninth Circuit decision and rejected class certification. In doing so, the court gave encouragement to the defense bar.
The Supreme Court, as presently composed, is no great friend of class actions. It's going to view any class actions with more skepticism.
Dukes vs. Walmart was the largest employment class action suit in history, charging the store chain with discriminating against women in promotions, pay, and job assignments. One critical element that would make or break the case would be how it was certified by the court as an injunction under Federal Rule 23b-2 or with damages under Rule 23b-3.
The difference is that Rule 23b-3, the damage prong of the statute, is more rigorous. It imposes more demands for certification upon the plaintiff seeking certification of the class. Plaintiff's lawyers, therefore, would like to try to find some way to get a case up for certification under Rule 23b-2, injunction, as opposed to Rule 23b-3, damages. It's a lesser showing is involved.
In 2001, a federal district judge ruled in favor of an injunction, making it easier for the plaintiffs to build their case, representing 1.6 million women in a class action against Walmart. But 10 years later, after an appeal by Walmart and mass criticism over what is being called an abuse of class action protocol, the Supreme Court would hear and throw out the injunction ruling, unraveling the entire case against Walmart.
That's going to be a positive development for a lot of class action defense lawyers such as ourselves, because previously, and under the Ninth Circuit formulation, where all you had to show was a predominant injunctive claim, plaintiffs' class action lawyers, good ones, were doing such things as combining their claims into part injunction, part damages, and then using the Trojan horse of the injunction to get their damages claims certified. That's now going to be much tougher to do.
The Supreme Court also shed light on the role of expert testimony in the decision to certify a case as a class action.
Previously, there has been no clarity on whether or not expert testimony has to meet the same standard on class certification that it would have to meet if you were offering it to a jury in a trial, and that's the Daubert standard, which in shorthand says the court has to be careful to watch out for junk science or science that doesn't have wide acceptance in the community.
The court's decision stated that the evidence in Dukes versus Walmart was so unreliable that the court did not have to address the issue of whether the Daubert standard applied, but the court gave an indication of how it feels about plaintiffs' arguments that Daubert doesn't apply on a certification motion.
The Supreme Court then went on to say, we doubt that is so, but even if properly considered, the expert's testimony does nothing to advance the case of the plaintiffs in the Dukes case.
That little phrase will likely get a lot of airtime in class actions to come.
The Supreme Court did fire this little mortar shot into the class action world that is a 5-word dictum that says, we doubt that is so, that one doesn't have to use the Daubert standard. In other words, anybody who wants to challenge the use of expert testimony in a class certification proceeding is now going to be quoting those 5 words and seeking to have the court really put the party that proffers the expert testimony to a showing that the testimony meets the Daubert standard, rather than just considering the evidence without any sort of rigorous review.
Although Dukes is an important employment case, the developments are important for consumer and business class actions too.